Hello friends, welcome to our channel Khatri Steno. Subscribe our channel for more dictations on daily basis. Be ready for the high speed passage. The petitioner, having been selected as a constable for being appointed in the Uttar Pradesh Police Services, was subject to police verification stop. His verification report was received to the effect that the petitioner was involved in a criminal case prior to his selection, and therefore such involvement does not entitle him to seek employment in the police services. Stop. Accordingly, his candidature was cancelled. Stop. The petitioner made a representation which was not being considered, as a result whereof he filed writ petition number 69759 of 2006, which was disposed of on 20th December 2006, to examine the claim of the petitioner and pass an appropriate order. Stop. In compliance of the aforesaid direction, the impugned order dated 5th January 2007 was passed on the ground that the petitioner was involved in a criminal case, and therefore such involvement does not entitle him for employment in the police services. Stop. After passing of the said order, the petitioner was honorably acquitted by the criminal court in case crime number 616 of 2006, and the decision was rendered by the trial court on 29th January 2007. Stop. It is therefore clear that the said judgment was not before the Senior Superintendent of Police when he passed the order dated 5th January 2007. Stop. The petitioner has approached this court questioning the correctness of the impugned order and has brought on record the order of acquittal through a supplementary affidavit. Stop. This court, after examining the said acquittal order dated 29th January 2007, passed an interim order on 28 to 2007 staying the operation of the order dated 5th January 2007 till the next date of listing. Stop. A counter affidavit has been filed on behalf of the state, and the same position has been taken, namely that the petitioner, being involved in a criminal case, was not entitled for being selected and appointed. Stop stanza. Learned counsel for the petitioner submits that the acquittal of the petitioner entitles him for employment. Stop. It is submitted that the impact of the acquittal order is that the petitioner was never involved in any criminal case, and even otherwise the petitioner had filed an affidavit before the authorities disclosing his involvement. Stop. He submits that this honest disclosure was in accordance with rules, and keeping in view the subsequent acquittal, the claim of the petitioner deserves to be reconsidered in the light of the same. Stop. Learned standing counsel, on the other hand, contends that the petitioner had an antecedent of being involved in a criminal case, and therefore it cannot be said that the impugned order is erroneous. Stop. He further submits that the order was passed on the basis of the material that was available, and in the absence of the order of acquittal, it cannot be said that the order suffers from any infirmity. Stop. Having heard learned counsel for the parties, the contention of the learned standing counsel to the effect that the order of acquittal was not in existence when the impugned order was passed appears to be correct. Stop stanza. However, in view of the subsequent development which indicates an advantage in favor of the petitioner, in my opinion, requires the matter to be reconsidered in the light of the order of acquittal. Stop. The petitioner, after having been acquitted, will be presumed to have never been involved in any criminal case. Stop. A perusal of the judgment indicates that it was a clean acquittal. Stop. The stain having been erased on a judicial verdict by the competent authority washes out the effect of involvement. Stop. This has to be viewed from another angle. Stop. A person, if falsely implicated, runs the risk of losing the opportunity to get a job, and it is here that injustice should not be allowed to dislodge an otherwise valid claim. Stop. Accordingly, the senior superintendent of police is required to reconsider the candidature of the applicant, and as such, for the said purpose, the order impugned dated 5th January 2007 is quashed. Stop stanza. The Director of Education has given an opportunity of hearing to all concerned and has examined the records. Stop. It has been found by the Director in his order dated 4/6/2007 that two separate posts were advertised by the institution for the post of lecturer in economics. Stop. While one post of lecturer in economics was on fixed honorarium basis, the other post advertised was for a self-financed evening course run by the college. Stop. It is claimed that the petitioner applied for both the posts, that is fixed honorarium basis, and also for appointment to the self-financed evening course. Stop. By referring to the statement of principal, it was observed that the petitioner was actually engaged by the institution for self-financed evening course, and he was paid salary from the funds of the Committee of Management from 6/8/2003 to 14/2/2004 at the rate of rupees 3,000 and 3,500 per month. Stop. It was further noticed that the petitioner was paid salary from the funds of the management at different rates from time to time. Stop. The director found that the appointment and working of the petitioner was only in self-financed evening course, and he was paid salary from the saving bank account of the institution number 1088 Syndicate Bank, Amroha. Stop. Further finding returned by the director was that since the name of the petitioner for appointment on honorarium basis was placed at SI number 3, as such, question of issuing any appointment to the petitioner for the post on honorarium basis does not arise, and as a matter of fact, no such appointment order on honorarium basis was actually approved or issued to the petitioner. Stop stanza. We have examined the order of the director, the claim made in the writ petition, as well as the various documents brought on record by the petitioner and the orders passed by this court in different writ petitions. Stop. The claim of appointment on honorarium basis as per government order dated 7/4/1998 has been examined. Stop. The claim for payment of salary from the state fund would arise only if a valid appointment in terms of the scheme is made by the Committee of Management on the format prescribed by the Director of Higher Education on honorarium basis against the sanctioned vacant posts. Stop. We find that no order of appointment in favor of petitioner actually was issued by the institution on the basis of advertisement dated 19/6/2003. Stop. From the recommendation of the selection committee, it cannot be denied that petitioner's name was at SI number 3. Stop. In the absence of issuance of appointment order as contemplated under clause 3 and 4 of the government order referred to above, no liability for payment of salary from state fund could be created. Stop. The petitioner has not been able to demonstrate that any payment whatsoever on honorarium basis was released to him. Stop. It is quite obvious that as the name of the petitioner appeared at SI number 3, issuance of an order of appointment in favor of the petitioner was otherwise not possible, ignoring the claim of others who were higher in rank. Stop stanza. We have gone through the pleadings of the writ petition and its annexures, and we find that the petitioner has not disputed his appointment made against the self-financed evening course for evening classes. Stop. The only statement made in para 24 of the writ petition, stating therein that the director illegally relied on the statement of the principal that the petitioner has been appointed under evening classes, and that the said finding is not based on any evidence is not sufficient. Stop.